It is true that this particular campaign is quite narrow in its goals. Our model legislation directs state executives to review Guard call-up orders for their legality and to withhold state Guard units absent a lawful authorization. This is a narrow road, but it is a road that leads to an essential debate. Shall we be the America that puts its faith in its people to provide for the common defense? Or shall we become another country entirely, unrecognizable to the aspirations of the revolutionary generation? And on this day, here today, 24 hours following the inauguration of Barack Obama, our direction for action would seem clear.
And as Ben has said, I'm Karen Dolan from Cities for Peace, based at the Institute for Policy Studies here in Washington, D.C. And we're very honored to be part of a broad array of organizations, many represented in this room that Ben mentioned, and veterans groups and citizens and activists and locally elected officials nationwide in this effort. And we are, as we know, all know that we're embarking on a new era. Thank goodness that the old one has passed. But it's incumbent upon us to work together now to be sure to reverse the abuses of power that have taken place over the last 8 years. And I think that this campaign is one of the most important that we all need to work on together to be sure to restore to we the people, to the states, the rights that are rightfully ours, and to bring home our National Guard.
From my vantage point, sitting in the Vermont House, I have to express my frustration. Vermont National Guard members belong in the service of the state unless called properly into federal service. When a Vermonter or a Texan or a Californian signs up to be a part of the National Guard, they are demonstrating an impressive commitment to duty. When I look into the eyes of these young men and women while they train to achieve excellence, I am moved. They have so much commitment. These brave men and women cannot question the chain of command. That's my job. As a politician, I have to ask the question of whether the orders at the top are sound, are legal. Again, today, there is no legal basis for the federalization of state Guard members.
Mike, the bill that you inspired and we wrote about a year ago, let me make this confession. It was really, in a sense, a very radical bill. It demanded that the U.S. government follow the law. At issue was Congress's 2002 authorization for use of military force, in shorthand call it AUMF, and how the AUMF has been followed or not followed since the 2003 invasion and occupation of Iraq. Recall that the case for the Iraq War divided the Congress and the American people. Congress did adopt it, propelled by the pressures of post-9/11 politics. And though it shouldn't have adopted any AUMF at all, which is now clear to a vast majority of Americans, Congress at least hedged its bets by limiting the authorization to just two purposes. One was the threats posed by Iraq and its supposed WMDs. The second purpose, and the last purpose, was to enforce all relevant UN Security Council resolutions regarding Iraq, and they were resolutions deriving from and after the first Gulf War. It became pretty clear soon after the invasion that there were no WMDs and that Saddam Hussein posed no threat to the United States, heinous as his regime was. Nor were there any relevant Security Council resolutions left to be enforced. But it became equally clear that whatever Congress said or didn't say posed no barrier to the Bush administration in pursuing and continuing the war. How could that be in a government of laws? First, courts almost always refuse to hear war powers cases. And the reason they give for not hearing them is that they raise political questions, not suited for judicial disposition. Yes, Congress could have theoretically reined in the president, but although Congress authorized the war by a majority vote, it would have taken a 2/3 vote of each house to override a presidential veto of a bill that had a withdrawal timetable. What Congress starts, it cannot easily stop. So President Bush could and did continue to ignore the limits of the AUMF with impunity right up to yesterday. That's where the states and bringing the Guard home come in. We fervently believe that a governor may, and indeed should, resist a federal call-up order based on a law that has, as Michael put it, by its own terms expired. That exactly fits the 2002 Iraq AUMF, and it's very different, by the way, from objecting to a federal call-up of the Guard because the governor may not like the military action in question. That sort of discretion by the governor, the Supreme Court has ruled out, at least till now. All laws passed by Congress are presumed to be valid, and extreme care should be exercised in resisting a National Guard call-up authorized by Congress, and this campaign meets that cautionary test with flying colors.
Compared to active duty troops, lengthy deployments into combat zones are especially difficult for Guard members and their families for several reasons. Number one is employment or business. Often Guard members come back after a deployment to find that they have been replaced in their jobs. Guard members who have small businesses find it virtually impossible to stay solvent in the year that they are deployed. Training and equipment. Guard personnel do not receive the same level of training and do not have access to the same equipment they will be using while deployed. Frequently, Guard units are split up on deployment and are not serving together. Anecdotal evidence shows that Guardsmen are not treated as equals by their active duty counterparts. Family support. Because Guard families do not live on or near military bases, they do not have access to the same support structure, medical care, or communications. Veterans for Peace believes that no combat personnel should be in Iraq or Afghanistan and calls for the immediate withdrawal of all U.S. military troops, beginning with the National Guard, as well as cancellation of activation and deployment orders for upcoming Guard deployments. The National Guard should be respected and utilized for the mission for which it was designed, to protect the people and property of the United States, and not as a tool in an aggressive war of choice.
In New York State, we are very thankful to have two state senators who have wholeheartedly supported this campaign, Senator Bill Perkins and Senator Eric Adams. Unfortunately, they could not join us here today, but in your press packets, you will find a statement of support from Senator Adams. These two senators have already co-sponsored and introduced a resolution into our state legislature demanding no further federalization of the National Guard.
In our view, the National Guard should not take the place of regular soldiers. The primary purpose of the Guard, we believe, is to defend the state of Maryland, not to be a backdoor draft. The Bush administration lied to Congress and to the American people about the reason for the war in Iraq. On the basis of these lies, Congress passed an authorization for the use of military force, the AUMF. But Congress, as has already been said, severely restricted the military role in its AUMF. Now, the Bush administration has completely ignored the terms of the AUMF, and it continued the war and occupation for years after the military roles specified by Congress were moot.